CV15 is now in session.
Thank you. Be seated. Counsel, before we begin, and I start calling cases when maybe I'm needing to call different numbers or all the numbers or something else, are you intending on arguing, these are of course back-to-back as you're aware, are you intending on arguing basically a single argument, or will it be more helpful to your argument if we look at these both as 754 and 799 or whatever they are, 755?
Your Honor, Isaac Gabriel for AOR Direct, the appellant in the 2014 case, appellee in the 2013 case. I had to set it up to argue them independently. I don't actually think there's much overlap.
And that's our position. In fact, we have different lawyers arguing each case. So,
And we were concerned about that. All
But
right.
we want to make sure we question you, Mr. Berg, on everything.
thank you, Your Honor.
Okay.
I appreciate the opportunity.
Good.
to talk.
Just a little surprise.
Be advised, counsel. Thank you. Now is the time set for oral argument in cause number CACV 15-0754, AOR, and my pronunciation is BUETO. Is that correct? Okay, that'll work. For everybody's information, the proceedings are being audio and video recorded, so as you're all aware at this point, it will be on YouTube unless we screw up the process of either recording it or getting it there within a couple of weeks. Enjoy your argument a second time. Counsel, each side will be entitled to the normal 20 minutes. We would ask that you respect that time period. The timer on the podium will let you know how much you have left. An appellant, as I'm sure you are aware, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try not to take up the entire 20 minutes. Ultimately, however, it is your responsibility to maintain that time for rebuttal if you wish to have it. We've reviewed the briefs this morning. We have conferenced the case this morning. We are well aware of the facts and issues attendant to this argument. We certainly have questions, and I'm not going to tell you there's absolutely everything we understand in this circumstance, but we're here to have you advise us about that. Keep in mind, though, that we have conferenced, we have reviewed the briefs as late as this morning, and hopefully that will help you in deciding how you want to formulate your argument. Counsel, when you come to the podium, the last thing I would ask is that you state your name and who you represent so that we have an accurate record in that regard. And with that, the appellant may begin.
May it please the Court, Timothy Berg of Fenimore Craig, on behalf of Appellants BUETO, LLC, and Scott Miller. I'd like to save 5 minutes for rebuttal. In this case, the trial court erred when it granted summary judgment on BUETO's contract counterclaims, where there was sufficient evidence to create genuine issues of material fact as to whether there was an agreement to pay commissions from AOR to BUETO on media purchases for cable shopping network and on third-party referrals. The primary issue that should be tried is, was there such an agreement? For purposes of demonstrating that there was a genuine issue of material fact, there's significant evidence of this agreement. First, Mr. Miller, the appellant, testified that AOR, Mr. Dompier, had agreed to pay commissions on any media purchased or on referrals at a rate of 5% or a third of the net commissions paid to AOR if the commission to AOR was less than 15%. Second, there were 12 checks issued by AOR to BUETO in amounts that are, well, certainly create a genuine issue of material fact if there's any explanation other than them being some sort of commission split. They're in amounts that, while AOR had argued that they were gifts, they're odd amounts to be gifts, let's put it that way. Additionally, AOR issued 1099 forms to BUETO and listed the amounts on the line of a 1099 form that, if you go read the 1099 instructions, would be consistent with the compensation split, with compensation paid by AOR to BUETO and not with a gift.
So, counsel, you're saying we can rely on the past practice of the parties to interpret?
If you look at the AROK case, I don't know if you say that AROK or if it's AROK, but it's a decision written by Judge Langford. What he says is when you've got the basic terms of the agreement, and here you've got at least genuine issue of material fact that there was an agreement to pay 5% or a third of the royalties, you can look at the past practices of the parties, in this case the checks that were issued. You can look at custom and usage in the industry, and we submitted declarations from a number of witnesses that it was a common practice in this industry for the media buyer to remit or pay back a 5% or one-third payment back to the company purchasing the media. You have the forensic accountant's report that says the checks from AOR to BUETO correlate with the cable shopping network's media purchases. You have the declaration of Mr. Hartunen, who was the owner and chair of Apex, that this is the practice that Apex followed when it did business with BUETO. You have Mr. Miller's declaration that he wouldn't have moved his business from Apex to AOR if AOR hadn't promised him the same payments. You've got the logical assumption that if Apex was paying him these payments, and that if that practice was common in the industry, there'd have been no reason for Mr. Miller to keep his business at AOR if they hadn't promised to pay him those payments. You've got Michelle Green's declaration that when she worked at AOR, that these payments were made to that these payments and discounts were common in the industry and were paid by AOR to other people. You've got Mr. Love, who says that Mr. Dompierre confirmed in front of him a commitment to pay a third to BUETO on both purchases by cable shopping network and on purchases by third parties or referrals by that were referred by BUETO. I think when you take all of that together, there is at very least competent evidence of a genuine issue of material fact that meant the trial judge shouldn't have granted summary judgment in this case, and the case should go to trial on the contract claims.
What's then your response to the principal argument I think AOR makes, which is Mr. Miller testified in his deposition that this was to be a mirror image of the the Apex agreements, and it's not really a mirror image?
Well, I think there are two answers to that. One, Your Honor, is there's a lot of evidence here, and I don't think it is appropriate at summary judgment for the court to decide, given the massive evidence of some kind of agreement here, that just because Mr. Miller may have been in error about exactly how much it mirrored the Apex agreement, that that's a summary judgment issue. I think that's an issue. Mr. Miller is going to have to get up and testify in front of a judge or a jury, and it's for the judge or the jury to decide whether Mr. Miller's story is credible, whether Mr. Dompierre's story is credible, whether the declaration of these other witnesses. The other thing, and I think this is important, if you go to look at Mr. Hartunen's declaration, what Mr. Hartunen says is we had these written agreements between Apex and BUETO, but as a practical matter, we didn't always abide by all of the specific written terms. We had a practice of doing this, and what we did at Apex was pay them a third of their purchases and paid them a third on referrals. And I think when Mr. Miller says he's mirroring the Apex agreement, it's certainly, I think that's what he means, and it certainly is something the trier of fact could decide that he meant. The key case I think that the court needs to focus on, and I've mentioned it already, is the AROC case. Plaintiffs rely on a series of cases, Payette, Savoca Masonry, and Goldbaum, that suggest an old-fashioned Williston kind of formal rule of what has to be in a contract. And I think what's clear from Shade versus Dietrich, which was decided by the Supreme Court, and from AROC, which was decided by this court, is that that's not the test for whether you have an enforceable contract anymore. If you have evidence of a contract that contains sufficient terms to be enforced, and this one does, they pay me a third of, or pay me 5% of what business I send you or business I refer to you, that's enough. And what AROC and what Judge Langford tells you in AROC is, if you have that kind of agreement, you can then look to a course of dealing between the parties. Again, the checks, the 1099s. You can look to custom and usage in the industry. Again, the testimony of the 3 or 4 witnesses we put forward in declaration saying it was standard practice to pay these sorts of things. This is how the industry works. You can look to the testimony of the witnesses. And what we're asking you today here isn't to decide there was a contract. What we're asking you to decide, and I think this is a critical importance, is that there is enough evidence here to create a genuine issue of material fact that there is a contract, and there's evidence from which a jury or a judge could find that contract exists and enforce it. And what AROC tells you is so long as there's enough there that you know what the parties promised and you can enforce it, other terms can be filled in by course of dealing, by custom and usage, by extrinsic evidence, by all of the other tools that judges usually use in interpreting or filling out the terms of a contract. And I think that's the situation we have here. I think there is it's not just a little bit of evidence, it's not just a scintilla of evidence. There is a significant amount of evidence both from Mr. Miller and, importantly, from other third parties and from documents and from the course of dealing that would allow a trier of fact to conclude there was, in fact, a contract here, and it's an enforceable contract. It seems to me at that point, the trial judge, with all due respect to the trial judge made a mistake in deciding that this was a summary judgment case.
Is it then your position that there are issues of material fact on AOR's argument that Mr. Miller terminated the agreement?
Yes, Your Honor. We think there are 2 levels of material fact issues there. One is if you read Mr. Gabriel's brief, it's clear that they talk about being terminated on 2 or 3 or 4 different dates, which if you can't figure out exactly when it got terminated, that ought to be a fact question for the jury. Secondly, I think it is also possible for the jury to interpret what Mr. Miller told AOR as, I'm not going to buy any more media from you going forward through CNN, but not that I'm terminating your obligation to pay me what you owe me on what you've already bought for CSN. I'm sorry, it's not CSN, or on the third-party referrals going forward. Again, if you read those emails, what he says is, I'm not going to buy from you anymore because you've given a better deal to my competitor than you've given to me. But it doesn't say I'm terminating the agreement. And so I think there are genuine issues of material fact there, Your Honor. To the extent these folks rely on the statute of frauds, I think Judge Reyes got it right. Part performance takes you out of the statute of frauds for purposes of an equitable remedy, and here this counterclaim is for a set-off and an accounting, and therefore it's out of the statute of frauds. In addition, the agreement could have been performed within a year because there were termination provisions, and therefore it's out of the statute of frauds. One last quick point, and then I'll sit down and...
You go to the last quick point. Of those 2 arguments on the statute of frauds, do you think one is stronger than the other?
I do. I think what Judge Reyes found is a stronger argument. I do think this is a case where there was part performance, business was referred, payments were made, part performance on both sides. And I think that because these are equitable claims in the nature of an accounting or set-off, that's stronger. I think the other one also would be sufficient to take it out if the court concluded that didn't that Judge Reyes was wrong.
Does it make a difference that yes, your client did request an accounting, but as I recall, it also just sued for breach of the commission, the alleged commission agreement, just a plain old breach claim, which would not be an equitable claim.
It is here, Your Honor, because it's a set-off. Basically, what they have claimed is that we owe them money. We've said, yes, we owe them some money under this note, but we think we owe you less than you're telling us because you owe us money back. It's a set-off. Mm-hmm. I also think we asked for an accounting, and so long as that accounting claim is in there, there's an equitable claim that would take the agreement out of the statute of frauds, even if the court, for some reason. In addition, there is a restitution claim here that would make it an equitable claim. Finally, and really quickly, there are genuine issues of material fact on whether the court properly awarded default interest. Both the controller of BUETO, I say several I think both Mr. Miller and the controller testified that they offered payment at different times, that Mr. Dompierre told them, don't worry about it, we'll square it out later, we're still figuring out other things we owe you and you owe us. And certainly until they unequivocally demanded payment, there was no default, and interest should not have run. Again, we're not saying you have to conclude that. What we're saying is there's a genuine issue of material fact as to whether they waived payment when we offered it to them and they turned it down. I'm going to save the rest of my time for rebuttal if the court has no further questions.
Thank you, Mr. Bird.
Good morning, Your Honors. Isaac Gabriel from Quarles and Brady, appearing on behalf of AOR Direct, LLC. Your Honors, I'd like to start really with some concessions that appellants made in their reply brief that I really think carry the day here. In appellant's reply brief, they made some statements, and I'm quoting here, which really show that there was never a meeting of the minds. Quote, much of this evidence emerged in depositions and discovery, causing BUETO to change some of the details of its argument. Second quote, as is evident from his testimony, Miller simply did not know what was in the written forms. Miller was mistaken to the extent he believed those written forms reflected the Dickard deal and the actual course of performance between BUETO and Apex. The third thing they try to say is they try to explain this away by saying modern practices allows a party to change its theory of a case if warranted during the course of discovery. We're not talking about changing a theory of a case. We're not talking about pleading breach of fiduciary duty instead of breach of contract. We're talking about a proponent of an oral agreement who himself could not adequately describe the terms of that agreement.
But does he have to, counsel, if you have substantial performance over time?
Well, so a couple of things, and this is kind of the fallacy of this whole case. They keep pointing to this. They claim there's performance. Okay, nothing.
Right, excuse me, but you did write checks. There is a history of check writing.
Correct.
There are 1099s that have transferred, paying for something.
Correct.
I'll bet that would be. I bet that those could be tied back to the underlying contracts under which they assert that the commissions were paid. The value of services rendered?
No. In fact, they had an opportunity to do so and could not. They had someone who was supposed to be independent, who the court found was not, who expressly concluded that it did not match. In fact, she looked at it. This is at record 145 in the case. It's our motion to strike her report. She looked at it and first said, okay, Coin Vault, which they originally pled and which they said was part of this agreement, could never have been included. So she excluded that entirely. Then she looked at CSN and said, I can't find a correlation to CSN payments either, because she said, at least that matches the agreement. She said, if CSN, you look at that amount of checks that were paid, not a single month lines up for the prior month. So if a check was paid in October, it doesn't match September. If a check was paid in August, it doesn't match July. And we would have paid too much. We would have paid actually about $100,000 too much under that scenario. So to try to get to any sort of correlation at all, she worked backwards. And when I took her deposition, she had to concede that she excluded payments to try to find any correlation. And she had to concede that her method was arbitrary. Those are her words, and you can look at her testimony from her deposition. She used an arbitrary method to try to establish any correlation. And she actually testified that it did not match the agreement. The other key part on performance here is their case really hinges on this notion of referral fees. If there's no referral fees, there's no case. There's no damages. Because what my clients paid, again, was more than what CSN would have been due under this, even if you followed this 2003 Apex agreement. So when you look at part performance, what they say is, well, you have part performance. You have no part performance of any referral arrangement from any third party. And without that, this case fails. Scott Miller admits that in his declaration in response to the summary judgment motion, paragraph 63. He says, I have never received any payment for any third-party referral from AOR. Okay? That kills their case because you don't have part performance of any referral.
So you just have a total breach? I'm missing the point.
Okay, so
I'm missing the point. He's saying that, well, under his version of the arrangement, AOR agreed to pay a commission on third-party referrals. And as I also understand from paragraph 63 and other statements, he is saying we didn't get that money. We were not paid.
Okay, so two things going on.
Right.
One is, what they're trying to say is we have part performance and that proves you had an agreement, right? So they're kind of working in reverse. They're saying you have some performance here and that shows we had an agreement. You have no performance relating to any referral agreement.
Well,
so
I
now,
guess I looked at it as one happy big ball of wax, that there were elements of the agreement. One, commissions on BUETO buys, and commissions on third-party referrals. That it was all part of one agreement. Maybe a finder of fact will decide, yes, on the BUETO direct buys, not so much on the third-party buys. But those are fact
no,
issues.
see, I don't think that you get to submit alternate forms of a contract to a jury. What the case law says,
On alternative facts, eh?
right? What the case law says is the juries don't create contracts, right? Juries just enforce contracts. So what contract is being submitted to the jury right now? And let's get rid of another fallacy here. Mr. Miller never, ever testified as to what Mr. Dompierre said. He said he could not remember what he said. He said he remembered the gist of it.
This is what concerns me, cutting to the bottom line here. Mr. Miller testified in deposition about the arrangement from his standpoint that he had with Mr. Dompierre, that it was going to be fashioned after the Apex agreement. We would operate exactly the same way we did with Apex.
Mm-hmm.
And then he uses the word mirror. Well, I look into the mirror and I may see a rough approximation of me, or I may see me in the mirror exactly, pristinely, precisely as how I look. These are a variety of ways to describe a working arrangement that he says he had with Mr. Dompierre. The fact at trial that you may well be able to cross-examine him in a devastating fashion doesn't mean he doesn't get to the jury, especially when you take his comments and support them by the third-party evidence from Mr. Hart, Mr. Love, Mr. Mezek, yeah, who substantiated and supported the comparison with Amex, and also the statements that Dompierre made directly to them about paying commission. So isn't that enough just to get to the jury?
No. I mean, not. Our position is obviously no.
Yeah.
And the reason why is that Mr. Miller carries this burden, right?
Mm-hmm.
Oral agreements have to have some higher scrutiny under Arizona law. And when you have an oral agreement,
Wait. Where's the case that says that?
I believe the Piat case says that. I believe there's several cases that say that we've cited in our briefs. But regardless, an oral contract has to at least have the definite and sufficiently described terms for the parties to even have a meeting of the minds. And that's a question of law, right? I mean, have you even met your prima facie burden to prove up a contract? And here, what Mr. Miller testified to was, first he said, we agreed to follow an Apex agreement exactly. When I questioned him and said, well, which one, because these all have different terms, he said, I don't know. I don't recall. Then, when you look at the agreement that is the Apex agreement, the only one that could possibly have a commission aspect to it, which is the 2003 agreement, it doesn't mention referrals at all.
But we still have Mr. Hart's testimony in his declaration that even though, for example, the other two Apex agreements did not have commission arrangements, nevertheless, Apex paid commissions, and Mr. Dompierre was very aware of all of that.
Okay, so here's again, this is part of the problem. All these cases that, like, let's take Aroke, the Aroke case that they cite to. The Aroke case, these specific parties in Aroke, and I forget the Indian School of Construction or whatever it was, they had previously entered into 3 contracts. They were all the same form. They all had the same terms. You then had a 4th contract that they were contemplating. You had a bid. All the parties agreed on the set of facts. You had a bid. You had an agreement that if we lower our bid, you'll use us as the sub, etc. So the court said, well, hold on. We clearly had an agreement here. The question is just whether or not it's too vague. And we can go back and look at these 2 parties' prior course of dealing and fill in the terms. Mr. Dompierre was not an owner of Apex. Mr. Dompierre did not sign any of these agreements. Mr. Dompierre testified he's never seen them until this litigation. So you can't create a course of dealing between BUETO and AOR Direct based on really CSN and Apex's agreements. And that's what they're trying to do. They're not doing a course of dealing between 2 parties who had done this before. They're doing a course of dealing between a new entity where Mr. Dompierre was not part of a prior entity and saying, you're stuck with whatever Mr. Hartunian did. That can't form a contract between Mr. Miller and Mr. Dompierre. The only thing that can form a contract in this case are the discussions between Mr. Miller and Mr. Dompierre. And when you look at all these oral agreement cases, what you generally see is you see quotes. You know, this Embry case that they cite from Missouri. This guy said this, quotes. He said this. And so is that statement sufficient to go to a jury to create a contract? Here Mr. Miller said, I don't remember what he said. I just remember generally 5%, 1/3. Or he also said at least 5 or 6 times we agreed to follow exactly the 4 corners of this Apex agreement. And I asked him again. I said, so you're saying all the terms is what you agreed to? He said, yes. Later, when I asked him about termination, he said, well, yeah, just whatever was in there, that would be the termination right. Okay, so he specifically said in his head had followed one of these agreements. Now he's saying, well, I also had a different oral agreement with Mr. Hart at Apex, different entity, and I just would have assumed that when we said exactly that would have been included in that. That's essentially what his declaration on summary judgment says. That right there shows you don't have a meeting of the minds. If he said exactly this and Mr. Dompierre thought it was exactly something else, that's no meeting of the minds. That's the classic mutual mistake.
Isn't that a jury issue? I mean, really, it's a question for the jury to sort out, isn't it? I mean,
Not where Mr.
the
Miller-
judge here is essentially making almost credibility findings. That,
Not where Mr. Miller can't describe the agreement.
but he did describe the agreement.
But he's
maybe
changed-
maybe not with every bell and whistle, but he described the agreements in his deposition, albeit somewhat generally. I agree. His declaration was more specific. There's confirming evidence. I mean, I will be candid with you. I am struggling to see why there isn't an issue of fact here.
Well, I would point you to the Strauss case that we cited in our supplemental authority.
I looked at it.
I don't
There
know
was
if
a bench trial there.
the court found an agreement.
Courts do not make factual findings on summary judgment, not normally, not in this state. In the supplemental case, there was a bench trial to the court.
Yes.
And so there was a full exposition of all of the evidence, and the appellate court said, not enough.
Correct.
Well, we haven't had the trial yet.
But they have an opportunity. It's called the deposition, right? I mean, he has an opportunity to set his case forward. And he had that opportunity, and he could not describe it. That's the entire purpose of summary judgment. To simply say, well, I mean, I've said something. It may not be enforceable, but let's send whatever. I don't even know what we're sending to the jury, quite frankly. And the Strauss case reversed it, which is effectively a summary judgment finding for the other side. And the Strauss case, importantly, also said that, they tried to do the same thing. They said, well, you made this $125,000 payment. That was part performance. The court clearly said, this does not match the performance that you have described. So you can't rely on that. The Jones case that we cited from, I think it's Tennessee. I can't remember exactly, but it's the one about the college professor who came in. He taught a class. Then he wasn't allowed to keep teaching. He said the same thing. And he said, look, I partly performed. I came in. We had this agreement. And the court said, the performance has to match what you're claiming your agreement was. It can't just be just some performance of something, and that gets you to and they entered summary judgment in that case, and that gets you to a trial. So in this case, you have Mr. Miller, who himself cannot describe the agreement, who says, I don't know what we agreed to. I don't know which one it was, who said, well, included a different oral agreement. And if you go back and actually scrutinize these other declarations, so what they're essentially trying to do is have someone fill in the gaps where Mr. Miller himself doesn't know the terms. So Mr. Miller testified quite clearly that the only people who were present when this agreement was made was he and Mr. Dompierre, right? So then they say someone else, they bring in Mr. Love to try to buttress that, whose wife is an owner of CSN. And Mr. Love says that Mr. Dompierre, he says something to the effect of, Mr. Dompierre expressly said that he was paying Scott Miller third-party referrals, which Mr. Miller has said, I never got a third-party referral. So he's saying something that is clearly not part of the agreement. It's in his paragraph. It's in one of the last paragraphs of his declaration. He said, for other third-party referrals similar to the deal Dompierre offered me. It's undisputed in this case that no third-party referral was ever made. And he says similar to the deal. What's that mean?
Well, to be fair,
Okay.
the statement exactly is, we discussed the fact that Miller would get commissions relating to Silvertown's ongoing purchases relating to the coin vault program. Dampier had also made clear that AOR had been paying Miller through his entity BUETO a commission for media purchased by CSN and other third parties. So the fact that his recollection is that Dampier acknowledged that he had committed to make payments, that's the essence, that's the core of what that statement is. It's not.
Yeah, I think it undermines the entire sentence. I mean, he's saying that Dampier said, I've been paying him already third-party referrals, similar to what I offered you. Miller doesn't say that. In addition, what all these declarations try to do is they try to do something in later dates. Miller said the agreement was in 2010 or 2008. He couldn't remember. And he didn't say anything about discussions in 2012. He said Dampier was bound by this agreement in 2008, which he really couldn't describe. Then he fills in this conversation, which Miller never testified about, never had any recollection of. So you have a third party basically testifying as to what the meeting of the minds was between Mr. Dampier and Mr. Miller 3 or 4 years earlier. So
I guess I'm forgive me, but Mr. Dampier's statements to Mr. Love, I believe that's what we're discussing, are party admissions, and they can come in, so they're admissible. And a person can acknowledge that they have a contract. For example, I can acknowledge to Judge Jones that I have a contract with Judge McMurdy. And let's say Judge McMurdy sues me, but not today, please. But he sues me to enforce the contract. I then make the same argument you've made, but I have told my other colleague, Judge Jones, oh yeah, he's got me dead in the water. I have a contract with him. That's going to come in. Why isn't that? At least it's admissible evidence to create a question of fact.
I don't think it is where Mr. Miller himself can't describe it. I mean, the position that we would state.
It comes back to mirror image, and I mean, there are different ways to construe that, and I think a finder of fact can construe it very strictly. Mirror means every word, every I, every T, or mirror image is the basic commission arrangement.
I think that's the problem. Like, as you've just said, it can mean a lot of different things, and if that wasn't discussed, how do you have a meeting of the minds?
I think juries decide that.
I don't think so. You have to at least say, we had a competent meeting of the minds. I mean, look at the Piat case. In the Piat case, it was undisputed that they had an oral agreement. It was undisputed that the husband would work and put the wife through school and vice versa. And the court said, that's still too vague. Even though you have part performance where the wife actually did her job and paid for you to go to law school, that's still too vague. You didn't discuss enough of the details to have a binding agreement. I mean, here, what's a referral? That wasn't ever discussed. Mr. Miller said all we said was, we're going to follow this exactly. Well, what's a referral? It's not in this agreement. They've been doing business with Silvertown for 2.5 years. Why would that be a referral, but Coin Vault wouldn't? I mean, I would submit to the court that even saying, send me business, I'll give you 1/3. If you refer business to me, I'll give you 1/3. I'd say that's unenforceable. We haven't talked about how we're defining the business, what constitutes a referral, what if I expand the work? Is it just on the first amount of the purchase? So what if I then put in a bunch of effort and expand it from $100,000 a year to $1 million a year? Do you get that other $900,000, or you just get the first 100? You don't have the sufficient, by his own testimony, the sufficient clarity on what any of the terms were. I'm running low on time, so I would like to address a couple of the other.
What about unjust enrichment then?
Well, so unjust enrichment, again, you don't have an impoverishment in this case. So what every case says is you have to do something, right? You built a house, you have submitted materials, you were co-counsel on an attorney case where you did part of the work and didn't get part of the fee. They haven't submitted any evidence that they did anything in this case. There's not even evidence of the referral that they talk about. All you have is a separation agreement where CSN got kicked out of the company and AOR continued to do business with Silvertown, who was part of the company that they'd been doing business with for 2 years already. So they don't show any impoverishment, and that fails right there. I have 1 minute left, so I'd just like to touch 2 other things. If you're going to say that you have this agreement that does follow the 4 corners, then you have prior breach. And let's not forget that in the 2015 case, which is not an appeal, but which was consolidated with this case, Mr. Miller sued my clients for doing business with Silvertown. My clients counterclaimed on saying you have a past due media bill based on this arrangement that he claims they had. The court awarded summary judgment in my client's favor on that case. They awarded summary judgment on the contract, and they found that they were in breach of their media bill and had not paid them, and the only issue remaining was how much. So they were, even if he says he had this agreement, they were in breach of it, and that would excuse any ongoing performance. Same thing with the exclusivity provision. Even if they say we have this agreement, this Apex agreement required them to be exclusive. I mean, that kind of makes sense, right? If I'm going to kick you back some money, I'm going to be your media agent. So that's definitely a material term. It's in every one of those agreements. And they testified that we were never their media agent. They try to argue that we waived it. Each of the agreements has a non-waiver clause, which is enforceable under Arizona law. And the last thing I would say is Mr. Miller testified expressly that he terminated the agreement. His words. He said, I terminated it. I put in the official on June 1st.
Well, my recollection of the evidence on that is he had additional testimony, certainly in his declaration, that clarified or perhaps put some nuances on that.
Again, I mean, that's where you have a deposition. The whole purpose of summary judgment is to take the deposition, and our view is he submitted a sham declaration and that should have been stricken.
That issue has not been properly preserved, the sham deposition. The opening brief mentioned it in one sentence. Is not argued in any material way on appeal. I think it's waived.
We definitely argued it in one of our...
I've argued it in the trial court, but this is the appellate court.
Well,
you have to preserve arguments to us. A sentence stuck in the middle of a paragraph on one page does not preserve that argument.
Well, I mean, I would say the court could rely on any grounds and would submit that it was in there. But all right, I think I'm out of time.
Briefly, Your Honors. The case that tells you how to analyze this is the AOR case. Mr. Gabriel tells you that Mr. Miller and Mr. Dompier have to each be able to testify identically to all of the terms of the agreement, and that an agreement such as I will pay you, if you send the CSN business to me and you refer their business to me, I'll pay you 5% or a third of my commission, whichever is lesser, isn't a good enough agreement. And if you read AROC, that's just wrong. It's wrong for a number of reasons. One, the test of whether something's enforceable is simply, is there enough there? Can you tell whether there was a breach of an agreement, and can you enforce it? And you absolutely can. You can tell there was a breach, they stop paying, and you can enforce it. You can make them pay. That's all AROC tells you need, and all the restatement second of contract tells you need to have a contract. To the extent there's concern about other terms, what else does AROC tell you? AROC tells you can look at a course of dealing and you can look at custom and usage within the industry. Mr. Gabriel tries to get out of course of dealing by arguing that even though Mr. Dompier was Apex representative and the record's clear that he was the one that Mr. Miller was dealing with at Apex on most of these account issues, that AOR is a different party from Apex, so there's no course of dealing. What he ignores, however, is that you can also look at custom and usage in the industry, and there's significant third-party evidence here from Mr. Hart, Mr. Love, Mr. Mezak, Ms. Green, I think her name is, that this payment of 5% or a third is common practice in the industry. Mr. Miller says you can't tell what, or Mr. Gabriel says you can't tell what a referral is. Again, if you read the third-party evidence, it's clear that this is a common practice in the industry, and people who work in this industry know how it works. Or at least there's sufficient evidence to take that question to a jury. A jury can decide that it's true or it's not true, but there's evidence here that should have precluded summary judgment.
How would you distinguish the Payette case?
Well, first of all, I would distinguish Payette by saying that this agreement is more definite than the one in Payette. This agreement tells you what you need to know to enforce. The agreement says, I will send you business, I will refer you business, and you will pay me 5% or a third of your commission, whichever is lesser. The problem in the Payette agreement was it was unclear what amount it was that it would take to put the wife through graduate school. For example, she could have gone to Harvard, she could have gone to Arizona, she could have gone to Arizona State.
March, you go to ASU.
Absolutely, Your Honor.
My alma mater, I might
Absolutely, Your Honor. She could have gone to UCLA, and each of those would have cost different things. There was no clear term in terms of how long she would be in school or when she would start. I think Payette is frankly a pretty shaky read given Shade and AROC, but to the extent it isn't, the situation's different. AROC tells you where you have enough to know what the promise was, and you can determine whether there was a breach, that's enough, and you have that different amount, that different more amount here, for lack of a better term.
Counsel, can you address for me the issue of the payments that were clearly made and the 1099s that were clearly issued,
Yes.
but because the accountant couldn't directly tie them back to a percentage of X, that's apparently not something that can even be considered here. Can you
I
address that?
think, first of all, it can be considered here. Whether the accountant can tie it back or not is a different issue. There are 3 or 4 specific pieces of evidence here. One, they're the checks. The checks stand on their own. They show payments from AOR to BUETO in amounts that are, certainly would could create in the trier of fact an impression that they were calculated based on a certain amount. They're things like, $3,458.39. They're not $5,000 checks. Second, you have 1099s that say, show this on the form of other compensation rather than somewhere else. So that's evidence. I think if you read the accountant's report, what she says is, I couldn't tie it back to purchases by Silvertown, but if you take a look at it, the amount there is about 4.8% of what CSN bought. And again, the jury can believe that or not, but it's credible evidence of a promise to pay 5% or a little bit less than 5% if they were getting less than 15%.
Maybe they just weren't good with a calculator. Is that what you're saying?
Maybe they weren't good with a calculator. Again, it's something for the jury to decide. Mr. Gabriel came up here and made what I thought was a nice jury argument about why you all should ignore the evidence that's in the record. And if he can convince the jury to do that, that's what he's entitled to do at trial. But that's not what the trial court should have done at summary judgment. When you look at Mr. Miller's testimony that there was an agreement, when you look at Mr. Love's testimony that Mr. Dompierre confirmed the agreement to him, when you look at the testimonies of Green, Mezak, and Hart about, one, what custom and practice in the industry is, and in Mr. Hart's case, what those Apex agreements really meant and how they lived with them, all of that is sufficient to create a genuine issue of material fact here as to whether there was a contract and to take that claim to the jury. On that basis, we ask the court to reverse the judgment entered and send this matter back for a trial. I have nothing further unless you all have some questions.
Thank you, Mr. Burke.
Much.
And since this is kind of an atypical way of doing this today, I'll tell you that we do appreciate your argument in regard to the first issue, but don't sit back and get too comfortable. We are going to take the matter under advisement at this time, and in regard to CV150754 ruling, a decision will be made in due course. Now, counsel,